Okay, so I have tried about 3 times now. Oh, now it's about 5 to get this recording to work. So either this one is going to be really, really good, or I'm so frustrated it's just going to be terrible. So let's see how it goes. Um, all I want to talk about is really where we get this idea of how judges are appointed and approved and who has that power. And looking here, right here, read Article 2, Section 2, Paragraph 2. In that article and section, you would then find um, that the president has the power to nominate judges and justices, and the Senate has to approve of them. If you wanted to go into your pocket constitution and check that out, that's the language. It's not all in one sentence. You have to read through the paragraph. But so the president will nominate people to be federal judges and justices, and then the Senate will approve or not approve of those nominations. And that's how you get a federal judgeship. Now, what's the difference between a judge and a justice? A judge is anyone on the federal bench, and a justice is someone who is on the Supreme Court. State Supreme Courts, I believe, also use the term justice for their Supreme Courts. Okay. Then when we get into Article 3 is the article that lays out the judicial branch. A couple of key, just easy things. There is one court created in the Constitution. That is the federal Supreme Court. Other than that, the Constitution doesn't lay out any rules or regulations for courts. All of that comes from Congress through legislation. So the courts are not created in the Constitution. They're created in legislation through Congress. Congress starts that hierarchical plan with the Judiciary Act of 1789, which I believe Hip Hughes talked about in one of your earlier videos. Once we have that one court, then the Congress creates others. There are about 94 federal courts, federal district courts, I believe, 11 appellate courts, appellate divisions throughout the country. Okay, as I'll tell you in the next video, if you commit a crime, you would go to the court for that city, state, or district, depending on the type of crime, wherever you committed that crime. Requirements to be a federal judge, you have to have good behavior. Could the president nominate somebody who's never been a judge, isn't a lawyer? They could. It's not a prudent decision, but they could do it. George Bush nominated Harriet Mier, not to disparage Harriet Mier, but she really was not qualified. It was a bit of a scandal, controversy, and she ultimately removed her nomination because of that. So they can nominate anybody they want, but it has to be someone who can get through the Senate. Trials take place where crimes are committed. So whatever happened, wherever it happened, that is the court or the district that you would be in. Treason, I asked you to do this in one of the videos. Treason is waging war against the U.S. or helping the enemy. Okay, some of you got into some of the stipulations of two people. That's not the definition. Punishment is up to Congress, and Congress can do pretty much, they can determine the punishment to be whatever they want. Currently, it is death. That is not in the Constitution. That is determined by Congress. So this is a short, quick video trying to answer some questions about power of the court. This will get us started. Hopefully this makes sense after what you've been seeing. And I'll have a couple more short videos to kind of bring all of that information together. Okay.